federal judge ruled this week that Prince George's County violated the Constitution when it forced nearly 6,000 employees to take furloughs last year. Now the county is being ordered to pay the employees for 10 days of work at a price tag of $17 million. Many other jurisdictions are looking at that ruling and wondering what it means for them. Governor O'Malley is proposing furloughs for state workers as a way to trim a $700 million deficit. Some state officials say what happened in Prince George's County has no impact on what the state is doing. Attorney Steve Allen is here with more on just what the judge's ruling means. Good morning.
Good morning, Patrice.
All right, let's break down what the ruling actually was. They said it was unconstitutional, it violated collective bargaining agreement, and it violated a contract clause which bars states from passing laws that would, impair your contract.
Right. Article 1 of the Constitution in Clause 10 says that no state may take action which alters or impairs its obligations under a contract. Here in Prince George's County, the county had entered into collective bargaining agreements which created certain obligations upon them. They reserved the right to lay off people, but they did not reserve the right to furlough people. And what the court said is, since you didn't reserve the right to furlough people, absent a true emergency where you have absolutely no choice in the matter, go find another way to find the money.
All right, so why would that not impact what's happening with state workers or even workers in other counties where they're being considered for furloughs?
Well, if the worker is only protected by the civil service system, there is no contract. And under that circumstance, the governor or the county executives in the other counties would have much broader discretion. It's where you've given away your discretion by entering into a contract that this opinion applies.
All right, well, let's go back to something else you said about what happened in Prince George's County. They're saying if there were an emergency, no other way you could handle the situation, and the county folks are arguing we're in a recession. Other than laying off tons of people and cutting all these services, this is an emergency. This was the only way to handle this. So how can a judge speculate what should have been better by, going to your reserve fund or doing something else? How can a judge make that determination?
Well, the judge, of course, has the power to make a lot of decisions. In this case, Judge Williams decided that there were other ways to find this money. There was a reserve fund, there were certain services that could be cut. He said to the county, you made a deal. You should have had the foresight to recognize that we could have economic times like this, and you should have reserved the right to furlough. Having not reserved that right, unless there's no other way to pick up the funds, then you've got to honor your obligations. Interestingly, he only made the opinion effective for that one furlough. Okay. He didn't say to the county, you can't do it in the future. What he said is, you haven't demonstrated to me that there's no other reasonable way to address this problem.
All right. Very interesting. Steve, thank you so much. Well, coming up in our 7 o'clock hour, back to school.